Guardians and conservators can be awfully important in someone's life. Today we're going to talk a little bit about that. Hi, I'm Dan Covington. I'm an estate planning attorney. I help people get their affairs in order, get their trusts together, their wills, durable powers of attorney, advanced directives, all those sorts of things. So guardian conservator, you've heard of it. It's not really a very well-known topic, but a guardian and conservator are important in a couple situations where people need someone to help care for them. First is a minor child, right? In the absence of a parent, while a child is young, they don't have any capacity. They cannot go contract with a dentist for services. They can't consent to their own field trip at school, right? All these sorts of things. They can't sign up for their own insurance. So a minor child needs a guardian and conservator. And another set of persons is an adults with an impairment. This is just someone who cannot handle their own affairs all on their own. Sometimes that can be due to a condition they have their entire life, or it can be someone that starts losing capacity, trouble with their memory, dementia, Alzheimer's later in life, and just needs someone to help them handle their affairs. So you hear the term guardian and you hear the term conservator. What are those two things? The guardian, it's a pretty simple division. Guardian is someone who cares for your person or your health, medical things, all sorts of care decisions. A conservator is someone who cares for your finances and your property. So pretty obvious division there, but it is, you think of a parent would do both of these things, right? But guardian conservator, if they're different people, get to split up those duties. Now, in Kansas, you have the right to nominate your guardian conservator for your children. In your will or your trust, you can name, it's not really an appointment yet, but you can name if something happened to you and your spouse, for instance, and your child or children were still minors, you get to nominate guardian and conservator for that for your children. And under Kansas statute, as long as the court finds that the child is in need of a guardian conservator, and they are if they lack a natural guardian and they're still a minor, as long as the court finds that they're in need of a guardian conservator, the statute says the court shall appoint your nominee. So your nominee in your estate plan has great weight, as it should. So the other section of this is for an adult with an impairment, right? Like I said, that can be someone who has a condition their entire life where maybe they need some help with their affairs, but it can also be someone whose capacity fades a little later in life, maybe. So kind of two things on this front. That person, while they're well, they can nominate someone in their power of attorney document, and the court is to prioritize that person as a guardian conservator for the principal in the power of attorney document. Now, that's a little circular because you've probably heard me say if you get a good durable power of attorney document, you hopefully should not need appointment of a guardian conservator. So while that's kind of a safe backdrop, and I often in a power of attorney document do name a nominee as a guardian conservator, the power of attorney document should take care of things so that if I sign a power of attorney document, I name Bob to be my attorney in fact, the person who has delegated powers into my power of attorney. If that's thorough and covers business and healthcare decisions, that power of attorney document itself should carry the day, such that just by signing that and giving Bob these powers, I've pretty much taken care of things, and there should not be a situation where I need a power of attorney later in life. So there's some different ins and outs for minors or for adults who need a guardian conservator. I hope this clears things up, and I really don't intend to muddy the waters. It's a little bit of a complex topic, but it really works out simply. For instance, in a trust, you might, for children, you might say, you name a nominee in there as a guardian conservator for your children in case something would happen to you at a young age. But then your trust is also going to provide funds for your children, right? So it's kind of going to work hand in hand. There's going to be someone there under your trust, someone there who can provide funds, and your trust will provide the funds itself through a trustee, but also there's someone in the person of a guardian conservator who can sign that field trip consent form, who can take the child to the dentist and represent that they can speak for this child because the child's a minor. I hope this helps. Again, I'm Dan Covington. You can always find me at Estate Plan, Kansas.